Hello friends, today I will discuss on the landmark judgment of the Honorable Supreme Court decided on 4th of November 2020 between Rajnish versus Neha, which judgment is commonly known as Rajnish Neha judgment, wherein Supreme Court gave some guidelines and some mandates for deciding any maintenance claim. This Supreme Court judgment was passed on 4th of November 2020. Prior to start discussion on this Rajnish Neha judgment, I want to draw your attention on one judgment passed by the Honorable Delhi High Court. It is on your screen. In Kusum Sharma versus Mahinder Kumar Sharma, decided on 6th of August 2020, the Delhi High Court observed and gave a format for affidavit of assets and liabilities to be filed by both the parties in any matrimonial case having the claim for maintenance to ascertain the actual financial status of both the parties. So Delhi High Court in this case clearly stated that both the parties have to file one affidavit of assets and liabilities. What is the reason for filing that affidavit of assets and liabilities? To ascertain the actual financial status of both the parties. This was passed on 6th of August 2020 by the Honorable Delhi High Court. Now I am coming to the judgment of Rajnish versus Neha, passed by the Honorable Supreme Court on 4th of November 2020, whereby Honorable Supreme Court finally decided various conflicts or confusions in deciding any claim for maintenance in any matrimonial dispute. As we know, it is well settled that a wife can claim maintenance by under the provisions of different enactments. What are those? Number one, she can avail section 125 CRPC to claim maintenance from her husband. She can file claim for maintenance under the provisions of Protection of Women from Domestic Violence Act. She can claim maintenance in any matrimonial suit under Hindu Marriage Act or Special Marriage Act. So there are several opportunities, several avenues available to a wife, to a married woman to claim maintenance from her husband. And what will be the legal position if a wife files claim for maintenance under all the provisions of law or more than one of the provisions of law? Say a wife, Mrs. X, files one claim for maintenance under section 125 where the learned magistrate passed order for rupees 100. Again, she filed one case under the provisions of Protection of Women from Domestic Violence where the learned magistrate ordered for payment of maintenance at the rupees 150. And thereafter, in a suit for divorce between the same parties, the wife filed application for maintenance from her husband and the learned judge passed order for payment of rupees 200 per month in her favor. Now, what is the legal position? Is the husband is bound to pay all the three maintenance, 100 plus 150 plus 200, or the husband will have to pay the higher one? Till the passing of the Rajnish Neha judgment, there were conflicts on this point. But Rajnish Neha judgment made these conflicts clear. The Supreme Court observed that it would be inequitable, note the word inequitable, it would be inequitable to direct the husband to pay maintenance under each of the proceedings, independent of the relief granted in a previous proceedings. If the maintenance is awarded to the wife in a previously instituted proceeding, she is under a legal obligation to disclose the same in a subsequent proceeding for maintenance. Wife got maintenance order in a proceedings under section 125 and she got order at the rate of rupees 100 per month. Then she filed application for maintenance under the provisions of DV Act. She is bound to disclose that in a previously started proceedings she got the order of rupees 100 per month. While deciding the quantum of maintenance in the subsequent proceeding, the civil court or family court shall take into account the maintenance awarded in any previously instituted proceeding and determine the maintenance payable to the claimant to overcome the issue of overlapping judgment. The claim of maintenance is being overlapped because court can order under section 125 if she files for, court can order under the DV Act, court can order under Hindu Marriage Act or Special Marriage Act. So the same claim, similar claim can be filed in different courts under different provisions and the judgment is being overlapped. Then what will be the legal position? Number one, wife is bound to disclose any maintenance allowance passed by any previous proceedings of suit or application. And the next thing is the court would take into consideration the maintenance already awarded in the previous proceeding and grant an adjustment or set off of the said amount. Say under 125 order was rupees 100, under DV Act order was rupees 150 and under Hindu Marriage Act or Special Marriage Act order is rupees 200. So the learned judge passing order under the Hindu Marriage Act or Special Marriage Act have to take into consideration the orders passed by the lower courts. That means rupees 100 and rupees 150 and set off the said amount if the order passed in the previous proceeding requires any modification or variation. The party would be required to move the concerned court in the previous proceedings. That means when three orders were passed, rupees 100, rupees 150 and rupees 200, the court passing the order for rupees 200 have to take into consideration of the earlier two orders and set off the amount. Ultimately, the variations of it is the husband is to pay the higher amount. That is, if there are three orders 100, 150 and 200, husband will have to pay rupees 200 because at the time of passing of this order for rupees 200 the earlier amounts will be set off. That means 100 and 150 will be included in this order and the consolidated amount will be rupees 200, the higher one. And it is the duty of the wife to disclose before the court all the earlier orders. She is bound for it. The next point is payment of interim maintenance. Here, the Supreme Court once again, though it has been clarified by the Honorable Supreme Court repeatedly, but still once again Supreme Court observes that the objective of granting interim or permanent alimony is to ensure that the dependent spouse is not reduced to destitution or vagrancy on account of failure of the marriage. And not as a punishment to the other spouse. So there are two things to be remembered. Number one, the basic purpose of maintenance, allowing maintenance, is to save the married wife whose marriage has failed, to save her from destitution or vagrancy. On the other hand, the maintenance should not be treated as a punishment on the other spouse, that means on the husband. So balance of the judgment should be here. The quantum, the payment of maintenance, interim maintenance or maintenance, should be decided keeping in mind that the amount should save the wife from destitution or vagrancy. At the same time, it should not be treated as a punishment upon the husband. There is no straitjacket formula for fixing the quantum of maintenance to be awarded. No formula can be given to decide the quantum of amount. In different cases, in different matters, in different subjects, let it be physics or chemistry or mathematics, we have different formula and we put the data into the formula and we get the output. Output is the final result. But in the case of deciding the quantum of maintenance, no such formula can be given. Here comes the point of judicial mind. Lawyers and the judge, both are the students of law. Both have the knowledge of law. But when a lawyer can become a judge, what is the basic difference between a judge and the lawyer? Judge has the judicial mind. A judge has the judicial mind which is required to be applied while passing every order. There is no straitjacket formula to decide the quantum of maintenance, and here the judge has to take into account all the guidelines and the enactments, and thereafter finally the judge will have to apply his judicial mind to fix the quantum. Here the Supreme Court again finally gave the mandate of filing one affidavit of assets and liabilities by both the parties, and at the end of the order, Supreme Court gave the format for the affidavit, and in the format there is mention about several types of documents to be attached with that affidavit, so that the concerned magistrate or judge may get a clear picture of the financial status of both the parties, financial liabilities of both the parties, and the living standard of both the parties prior to the marriage and after marriage. If you go through the judgment, in the last part there is the affidavit and there is mention of for filing all these documents. These are mandatory and these documents are to be filed in any court where any claim for maintenance have been filed, or I am defending any claim for maintenance. Both the parties will have to file this affidavit along with all these documents. Now, the Supreme Court gave some guidelines for determining the quantum of maintenance in Rajnish Neha case. I am reading. The court acknowledged that there is no straitjacket formula to calculate the quantum of maintenance. The court noted that the same should balance the applicant spouse's interest with the responding spouse's financial competence. So the wife is the applicant. Wife's interest should be taken care to save her from destitute and vagrancy. At the same time, court will have to consider the responding spouses, means husbands, financial competence. If the wife wants to lead a lavish life and the husband earns a meager figure of rupees 10,000 or 15,000 or 20,000, court should not order the husband to pay at the rate of rupees 50,000 for the wife, because the order should balance the requirement of the wife and the competence of the husband. It should not be a punishment upon the husband. The following items are included in the list. The court outlined considerations to examine when determining the amount of maintenance to be paid. Following items are included in the list. Some Supreme Court gave some list which are to be considered. The list is not final list. Other matters may be taken into consideration by the concerned judge. Number 1, parties status of both the parties. Number 2, applicant's need. What is the need of the applicant? In other judgments, the Honorable Supreme Court, I discussed in my previous episodes, that it should not be luxurious, but it should be sufficient to maintain herself so that she may not have to starve. The amount should save her from destitution and vagrancy. So the need of the applicant should be taken into consideration. The respondents, that means the husband's income and property. Not only the income, but the property will also have to be taken into consideration. The claimants, means who is claiming, the wife, liabilities and financial responsibilities. If the wife has to maintain her children, etc. The parties' age and employment status. What is the age of the parties? Now the question is, why this age will be taken into consideration? Why the employment status will be taken into consideration? Let me give one very practical example. A pilot. A senior pilot earns around rupees 8 to 10 lakhs per month. Quite a handsome amount he earns per month. And he is now at the age of 40. I don't know whether you are all aware of it or not. The life of a pilot is very much hectic. They have to suffer from tremendous stress. Their job is very much stressful. There is no routine that they can maintain due to their job. They may have to report at 1 o'clock at the night. They may have to report at 12 noon if he is called. There is no fixed routine. There is no fixed schedule. This is their job requirement, to meet their job requirement. And due to this very irregular life, there is no sleeping time fixed. There is no fixed sleeping time. There is no fixed time to take rest. There is no fixed time to take lunch. There is no fixed time to take dinner. Everything is irregular. Many of them, I met one very recently who is now my client, and I am sharing that experience with you. They started suffering from various health problems, and it becomes very much difficult for them to continue this service after the age of 45 or 48 or 50. So, though their official retirement age is 60 or 58, I don't know, but very few of them can continue the job till the age of retirement, and most of them go for voluntary retirement at the age of 45 or 50. So their earning will be stopped at the age of 45 or 50. So whatever they are earning till that age, they have to spend their rest of the life based on the income they could do till the age of 45 or 50, till the date of their voluntary retirement. So not only his monthly income will be taken into consideration, his age, if he is now aged about 43. So in normal course, it is expected that he will be able to continue his job for next 7 years. Due to this hectic nature. Now employment status, there is no stability, there is no guarantee of job in this field. During the lockdown period, there was more than 60% salary cut in one aviation company who is most reputed in India, and always we try to avail flight of that particular aviation company if we have to fly. And that aviation company had a salary cut of 60% since the inception of lockdown, and that salary cut is still going on, though at present there is no restriction in the aviation sector. So though the salary is 8 lakhs, but right now there is 60% salary cut. Number one, there is no guarantee that company will reimburse this salary cut after 2 years or 3 years. There is no guarantee. And there is no guarantee that if more competition comes in this aviation sector by other companies, whether this company will continue their business or will shut off. In case of shut off or in case of forcible voluntary retirement, the pilot will become jobless, and scope to get another job is very limited, because in our country there are only very few aviation companies, very few. So job opportunity is very poor, though if you get a job, salary is high. So don't go with the salary, check his employment status, check his age while considering the quantum of maintenance. Next point, the parties' residential arrangements, where the wife resides, where the husband resides. In one case, husband's salary is very high, and he booked one flat in Delhi. The flat is quite expensive, more than rupees 2 crores, and he took bank loan for that particular flat, and the builder could not hand over the possession of the flat in time, and even after 5 years the building is under construction, and the husband is paying the home loan EMI, and the husband is staying in a rented accommodation, and the husband is contesting a complaint case against the builder in the National Consumer Forum. So the residential status of the parties, residential arrangements of the parties, in this case the husband has been paying the home loan EMI, husband is paying rent for his rental accommodation. Now come and consider from the wife's angle. where the wife is presently staying. She may stay at her paternal place, her father's residence, where she is not paying any rent. She may stay in a rented accommodation where she is bound to pay rent. So these residential arrangements should be taken into consideration. Next point, parties' minor children's maintenance. Say the couple has 2 children and they are residing with the wife. So while considering the maintenance for the wife, the maintenance for these children, the expenses for these children which the wife is incurring, and as the children are residing with the wife has been paying, that has to be considered. Further, there can be another case that where husband is not paying a farthing to the wife, but the husband is paying everything for the children: school fees, school bus fees, tuition fees, dress, fooding, amusement, everything. Husband is doing everything for the children, but husband is not paying a single penny to the wife. So there may be several scenarios in this matter. So all these should be considered. And the last point, Supreme Court mandates illness or disability. Whether there is any illness of either of the parties or there is any disability. Disability of the wife means she may not be able to work, she may not be able to look after the children, she may not be able to earn her livelihood. Disability of the husband means she is not fully capable to exert his all energy to earn money. For illness, either of the parties, there will be some kind of expenses for medical treatment, medicines, doctor fees, diagnosis, everything. So these factors are to be taken into consideration. Now, the next point, date from which maintenance is to be awarded. Previously, we noticed that in some cases, judges used to order that the maintenance to be paid from the date of the order, and in some cases, maintenance to be paid from the date of filing. It depends, it used to depend upon the discretion of the judge. Now, it is not dependent upon the discretionary of the judge. There is mandate by the Honorable Supreme Court. We make it clear that maintenance in all cases will be awarded from the date of filing of the application for maintenance. This is the mandate. This is the particular wordings used by the Honorable Supreme Court. We make it clear that maintenance in all cases will be awarded from the date of filing of the application for maintenance. Now the last point, enforcement of orders of maintenance. How an order for maintenance can be executed, can be enforced. For enforcement or execution of order of maintenance, it is directed that an order or decree of maintenance may be enforced under section 28A of the Hindu Marriage Act, under section 20 subsection 6 of Domestic Violence Act, under section 128 of the CRPC as may be applicable. The order of maintenance may be enforced as a money decree of a civil court as per the provisions of the CPC. More particularly, sections 51, 55, 58, 60, read with order 21. So there are several provisions for enforcement or execution of the order for maintenance. In this matter, I want to share one experience. In a case in ADJ Durgapur, subdivision Durgapur, the learned judge was pleased to pass order for some amount, say rupees X. Husband used to pay that amount, and there was some default on the part of the husband. Say after 1 year or 2 years, amount accrued to rupees 2000, and till that date husband paid rupees 1500. So 500 is due. Rupees 500 is due payable by the husband to the wife. In this scenario, the husband who filed the suit for divorce filed one application for withdrawal of the divorce suit. Husband filed application for withdrawal of the divorce suit, where in a miscase arose out of the original mat suit. Wife prayed for alimony pendenti light, and the learned court was pleased to pass an order for such and such amount, and on the date of filing that withdrawal application, there were some amount due to be paid by the husband to the wife. In this scenario, the learned judge, after considering everything, observed that as there is amount pending to be paid by the husband to the wife, the original suit, the mat suit, cannot be allowed to be withdrawn. I am telling again, when the husband filed application for withdrawal of the original mat suit filed by him, there was some amount due by the husband to be paid to the wife, and husband filed application for withdrawal of the main suit, the divorce suit. The learned judge observed that as there are some amount due, the mat suit cannot be allowed to be withdrawn. In my opinion, that observation of the learned lower court is not in accordance to the law, because Supreme Court specifically said what are the provisions for enforcement or execution of the maintenance order, and in case of non-payment, in case of non-compliance of the order for maintenance, the aggrieved party, the wife, will have to avail the provisions for enforcement or execution of the maintenance order. No other provision, no other measure can be taken against the husband. If I am challenged about the last case which I told, where the learned judge of Durgapur passed such order, I can disclose the case number in my next videos. I was the advocate on record in that case, though the matter was thereafter settled between the parties due to my personal intervention, and right now both the parties are living their peaceful life, and I pray for their peaceful life for in future. Today I discussed the Rajnish and Neha case, the exact points which was finally decided by the Supreme Court. But this is not all. I will suggest all of you to go through the Rajnish and Neha judgment thoroughly. You will be able to learn many more things which I missed today. So those who are viewing this video, listening this video, I will suggest you, I will request you to read the judgment totally and thoroughly. You will be able to learn many more things. I am ending my today's video now. I am taking your leave. Thank you. Stay blessed.